if any, from item number 1 to 7. From item number 8 to 15.
Please, Your Lordship. I prefer an adjournment in item number 14. We have circulated the adjournments previously.
Give the date.
Yes, 27 July. From item number 17 to 20.
May it please, Your Lordship. Lordship, I beg to mention item number 17. Lordship, the conducting council is out of station.
May it please your Lordship,
Maybe
I
fixed,
am
Lordship.
putting respondent number 2 and 3 in this case.
Yes.
I filed a caveat, but my name is not shown. Caveat is attached to the records, but my name is not shown for the respondent number 2 and 3, Miller.
At the request of an adjournment slip has been circulated on behalf of the petitioner on account of inability of the learned advocate who has to address this court to be present today. Mr. Dr. Asim Chamwa, learned advocate who appears for respondent number 2 and 3, submits that his name is not reflected in the cause list, despite his having filed the caveat. Henceforth, the name of Mr. Chamwa, learned advocate, must be reflected in the cause list in this case.
I'm obliged.
Let this case come up for consideration. On when do you want it?
On Friday, Lordship.
No, not for Friday. Let me go.
I will be out of station till 11th of June, Miller. If it is not inconvenient, after 12th of June, Miller.
On 15th, Lordship.
Yes.
22nd June.
I'm obliged.
Your Lordship.
From item number 21 to 25.
The consider petition, I beg to mention item number 21.
All right.
29/7.
Maybe your lordship. So in item number 21, I have some small prayer in this matter. From item serial number 12 to 41, there was the stone cursor respondents, my lord. Stone cursors, my lord. Out of them, I was representing 14. But for a long time, they included non-cooperation, so I could not file the affidavit. Your lordship asked me to file, my lord. So I am like, I may be allowed to withdraw from all these 14s, my lord. That's what I mean.
Give a notice to your client and intimate the registry. There is a procedure. We cannot pass order.
My lord, I have even sent that letter, my lord.
So you file an application before the registry will place it then. May I please your lordship? My lord, I beg to mention item number 22, 23, and 24. My lord, both are analogous to the standing allowance.
All
My
right.
31st July. Any other request?
May it please the lordships. Lordships, may I please beg to mention an item for listing? Lordships, the matter was actually listed on Monday, the 5th of May, where I had pleaded that the pleading was completed and the matter may be listed for any other day, and my prayer was allowed. However, while intimating the standing counsel for the state, the private respondent was not informed. I deeply apologize for that, and I request to humbly allow the prayer to list the matter anytime next week, your lordships.
All right. Next one.
Deeply obliged, lordship.
May
Yes.
May I please, Your Lordship?
Yes.
Beg to mention an unlisted item for listing, Your Lordship.
Yes.
It's a WA matter 360/2024. It's regarding LPG distributorship, Your Lordship, and it has been pending since 19/4/2025. Sorry, 21/4/2025.
Sometimes in June. Yes.
15 June.
15 June. Oblige, Your Lordship.
Right. Yes. Daily list for this item 1 and 2.
May I please, your lord?
Yes.
My lord, there is an order regarding impleadment, my lord. My lord, we have prepared the amended first title, but for certain names, my lord, we could not file it. By Friday, we'll file it, my lord. Can it be taken up on next week, my lord?
We take it up on Friday. As prayed for
Fine.
on behalf of the.
My lord, Friday, my lord, some difficulty on
As
Monday.
prayed for on behalf of the petitioner. Let this matter come up for consideration on next Friday.
My
Thank you.
oblige me.
5, 6. Item 3 to 5.
Well, it appears that despite your lordship's directions, Willis, they have not bothered to file a counter.
We have just filed the affidavit, we have served the copy.
Why counter has not been
No, the
filed?
counter has been prepared and we have given the copy also.
Acha,
May it please your lordships.
yes.
Maybe
No,
they are
that-
outstation, so they have not received it.
No, it was just handed over. I'm told it was handed over 5 minutes ago in court.
Ah, that's in court. Don't
Yes,
say you
yes.
handed over the counter.
So we would need to.
No, we have handed over to the council here. I stands corrected. We have handed it over to the council.
Yes,
Not to the court.
today.
It
No,
is
today.
still to reach the court.
No, that's all right. Today, we will put in a rejoinder, Willis. The lordship will have to put a date then, Willis.
Yes, yes.
Short date may be given, lordship, because the matter is already settled by the Supreme Court, and also we have received 3 FIRs. One FIR is closed because of jurisdiction, other 2 FIRs are clubbed together, and the investigation is going on in Dispur police station. So when a parallel proceeding is going on, there is no meaning of having identical proceedings here.
Well, it's
Willis,
just
in
1
fact,
second,
we have-
Willis, just 1 second. It is quite ironical. It's a delicious irony. My learned friend says, give a short date. Your lordship's notice was issued on 26 February. They are filing a
Yes,
reply at the end of May, and he's complaining about a short date.
Because basically I am issuing the maintainability issue, not on the merits. Because if the other side will have to give, then they have to give us the complete transcript.
Anyway, Willis, now your
Transcripts are
lordship will
not
decide.
given. They have picked up 1 or 2 sentences from some newspapers or some articles, and they are giving lot of commentaries there. Editorial editing is there. So complete transcripts is also being asked by the.
Anyway, Willis, your lordship may give a date, Willis, whatever date.
Now, this matter shall come under the heading admission on the next date, subject to the convenience of the learned advocates. And in the meantime, you also provide the full transcript of the papers, newspapers, or whichever paragraphs have you extracted from his speech.
Yes.
Yes,
Willis, in item 3, we have in fact provided transcripts Willis, of most of
Willis, we
the.
have also
speeches.
provided, but if there's any deficiency, we'll do it, Willis, we'll do it.
All right. So just check up.
In the affidavit, it is clearly mentioned what is required.
where- Yes. All right. When would you file the rejoinder?
Willis, we'll take a couple of weeks to file it, but there are recess here also now.
You
We are also
suggest,
going to recess.
suggest a date.
In July, Willis, obviously, it'll have to be in July. Your lordship will say whatever.
Again.
If it is July, then after 15th of July.
Keep it in the first week of August.
Very well,
At
then
your
kindly put
lordship,
it on, Willis, 6th of August.
Correct.
6th of August.
Again, the counter affidavit on behalf of the reply affidavit on behalf of the respondents has been filed today in court. So, the learned counsel appearing for the petitioners seek some time to rejoin. So, let all these matters come up for consideration under the appropriate heading on 6th of August. Stop. In the meantime, the transcript of the
Willis, just before your lordships give that
Just-
direction, may I just say one thing, Willis?
yes, just
With your lordship's permission. Willis, sir, the full transcripts are maintained by the police
Mr. Singh, please,
department.
please wait for the order to be completed. In fact,
Fine.
you'd not find it offensive or anything
No,
difficult.
not offensive,
In-
Willis, but
in the
many
meantime-
transcripts are in their possession. Willis.
That's right. In the meantime, an effort shall be made to provide the transcript of the speeches which have been quoted in the petition for the convenience of the court.
Deeply obliged.
If it is not there, it is not there. If it is
May I
there,
suggest
give it
say-
to us.
Full transcript, not the curtailed transcript or excerpts. Because the
Manoj,
overall
I
meaning
find
has
it very
changed.
strange.
Wherever it is possible for you to
Hello.
give your transcript, give the full transcript so that we can
Yes.
question the.
My lords, I
Whatever
find
is
it,
possible.
my lords, we will try and give the entire thing that's available to us. But please appreciate it is being said on one hand that the police is investigating. They have every access to that full transcript. On the other hand, the people who bring this to the notice of the court are sought to be put in this. The other
Very
thing that
good. Whatever you can lay your hands upon,
My-
bring it to the
we
notice
will
of
do
the
that.
court.
I am
We will not-
grateful.
We will not be questioning you on that account. whether
Very
you-
well. I am so grateful, my lord.
But as far
My
as
lord-
possible, you provide that.
Also, just one last thing. I
Yes.
believe that affidavit has been filed in all the items, or has it only been filed in the
One
first and
affidavit
the
has been filed in one case, leading case, the same will be shared with the others.
And then that should not be a problem. One composite affidavit which shall be referred to in all the
In
cases.
PL 14, the affidavit,
Please,
the
my lords.
identical copies will be given to the other sides.
All right.
very well, my lord. So that we know
Mr.
that what
General,
we
ensure that all of them receive copies.
Lordship, we will do that.
All right.
Please, your lordship.
All right, 6th of August.
I'm
Hello.
obliged, my lords. Grateful.
Item 6.
Grateful, my lords.
Deeply obliged.
Yes.
Late Mr. Lordship. Lordship, we have complied with the order, Lordship.
Hey, what is it? Which
No,
matter
Lordship,
has been called?
The concerned matter, Surgeon Kumar Kamal Das, Lordship, appointment of principal in Bamun for a high school, Lordship. Lordship had given it in order to either to give the marks allotted to the petitioner,
Yes.
either the petitioner or respondent the 6th, Lordship.
Yes.
Lordship, we have complied with the order, Lordship.
You have complied with the,
Lordship,
is it a fact?
Not,
Lordship,
No,
we have
Lordship.
passed the
no,
order.
Show
Lordship,
it to
Lordship, I have given a copy.
I have a lot to tell you something. Lordship,
No, the order has been passed.
Lordship, I have been suffering for many years. You see, my B.Ed degree is stated to be invalidated by the government officials. And I am suffering for no reason. This is totally intentional, my lord.
Correct. Mr. Das, the difficulty with this court is that we are now dealing with the contempt petition. The
Yeah.
contempt was with,
No,
you
sir.
had filed the contempt petition
No.
that despite the orders of this court, the evaluation has not been made afresh so far as you and the other respondent is concerned. Now that they have done it, now do we enter into the merits of the order? We can't. Mr. Das, you'll have to appreciate this is something, this concerns, this may not be very much known to you, but the jurisdiction is limited. Now, whether the order is good, whether the order is bad, whether the order is deliberate, we are not to question it in this
Okay.
jurisdiction. The moment you challenge it, you say in the main petition, you have your main petition revived and say that it was deliberate or whatever, or you challenge this order before a superior court. We understand the difficulty. You are shortly to retire. But then contempt, what do we do? Now the order has been passed. There has been a delay of few days. Yeah, what can be done? This jurisdiction is not to be invoked now.
Lordship, in my favor, there are many orders were issued. But in my case, all the orders were set aside and quashed. But in case of, I am telling you. Just a minute.
Mr. Das,
No.
here we have remitted back this matter to the authority, the selection board. They have done their exercise. If you are agree with this order, you will have to file a fresh petition. We cannot go further.
No. Okay. They have made the mask this way. We are awarded 70 leads. We are awarded 70 leads.
Anyway,
We are awarded 70 leads. Now, why has it become to 16? First, what they have done?
Mr. Das,
They-
you're a
no,
party person. It is
Lordship,
they are not taking it
Lordship,
into-
I am not interested in the principalship. But my B.Ed degree is stated invalid.
No.
If someone call your degree from an university that is fake, what would you feel?
You do one thing. I mean, we are nobody.
Actually, Lordship, they are not interested to appoint me as principal of Bambanagara High Secondary School. There's something fishy. That is well known from this orders. I am
Mr. Das,
not
you'll have to-
satisfied with this orders. Okay, sir. I put this matter. So power. What is power, Lordship? Power is made. Powers can be used to dominate others. Power is not for do good for the others. They apply their powers to invalidate my valid BEd degree. They have power. My case was not properly elaborated in this court. You see here, in all the cases, Mojid Ali filed cases one after another from the very beginning. That I am awarded more marks by the school selection committee. But school selection committee has already replied it, sir. Re-examination proposal, but it was not submitted in. Only 4 points are there. Your Lordship.
Where was the question? Where was the question of deciding about the validity of his BEd degree? That was already decided.
Not already decided.
Just a minute. It was already decided.
Already decided, but Lordship.
But you were not called upon to decide on this.
No, no,
You were called upon to decide the matters.
Lordship, maybe please to come to the second last page of the Lordship.
You have granted, reduced his mark
Mark,
based on the performance. of the
Performance, Lordship. Lordship,
Performance
results were
of the school.
deteriorated after
Why did you have
he
to
was
mention-
appointed as a principal.
Right, but why did you have to talk?
No.
Lordship,
How did
Lordship, maybe please to come to the second last page of Lordship. Lordship, upon careful examination of the matter in terms of the office memorandum dated 26/12/2018, the State Selection Board observed that the result of Babundangura High School in the final examination for the year 2018 was 76.28%. However, the earlier selection board had considered a percentage of 84.88%, resulting in award 3 marks to Sergeant Kamal Das instead of 2. Lordship, the results
Lordship.
deteriorated, Lordship.
Lordship,
The
not
results
yours.
came down, Lordship.
No,
Lordship, not in an arbitrary manner, Lordship, we had given given
Lordship,
marks, Lordship.
fight page number 17.
On the other hand, Lordship.
Just
Please fight for that.
we have put a question to her. She is answering the court. If you try and gag her, it will not be good, no?
Yeah.
We are understanding that you have lost the battle here.
Yeah.
And you have little time left to challenge it. Therefore, we are hearing you. If we find any way out to give you some succor, we are there. But you can't talk like this. She's presenting her case. You don't discuss with her.
No, sir, I am not professionally advocate. I am
That
not-
we can see. That we
Yes,
can
sir.
see. Otherwise, you would not have insisted beyond a point.
I am being
We can
deceived.
see that you
I am being
not-
deceived, not only this time.
We
sir.
are not, we are taking you very seriously only for the reason that you are an academician. You obtained marks in the first instance, you were successful, but because of the repeated writ petitions by your adversary, you lost out on this. The other person also stands suspended. He is also not the principal. And now you're on your way out. But anyway, you are on your way out now. We understand.
No.
Do you think we would have waited
No, no.
even for a minute to
Lordship.
conclude this case?
Lordship,
But
just
then you
one,
can't-
just to clarify.
Just a minute. Just a minute.
2017, considering preceding 3 years result, 2017, 19 to 92.15. And in 2018, 76.28 and 2019, 84.88. The average is 84.43. The average is 84 point, and for that matter, sir, in OM 2018, 80 to 89% passing rate is the
When do you retire?
in July, so practically this month, sir, because July is the summer vacation.
You challenge this. You
Not,
challenge.
sir, I'm not going to challenge that. Shame. It's useless to challenge, sir.
Yeah.
If everyone in the government and the court, sir, don't want me the principal, then what can I do? What can I do? Nothing.
Pursuant to the judgment dated 6/4/2026, passed in WA number 402 of 2025. The marks allotted
One more.
appellant and respondent number 6 has been revisited, and now an order has been passed as corrected by this court. What is the date of the order?
6/4/2026.
What is the date?
On the meter, Your Lordship, 6.
No, it's this order.
15/5/2026.
16.
What's the order of the
26/5.
26?
26/5/2026. A copy of the order has been served upon the applicant and has also been filed across the board. So the same is taken on record. With the passing of this order, there would be no necessity of continuing with this contempt case number 245. The contempt case stands aside. In case the applicant is aggrieved by the order passed by the respondents, he may, if so deemed necessary, challenge the same in an appropriate procedure.
Your Lordship, just when my EADB invalidated, you see 27 July 2021, this order. I challenged this in 3558 case number. They wrote here this like this. On the other hand, Sri Sajal Kumar Das Pujiri Bhamon High School, Borpeta obtained his BA degree, Borpeta BT College in the 1997, and the college got recognition in 14/9/2005, and his BA degree is invalid as per legal provision of the NCT, and that's why my candidature was cancelled based upon this order. But when NCT authenticated my BA degree, this order should be passed.
No, we have clarified in our order that you have a valid BA degree.
No,
But the assessment has been made on other
He
indices.
was appointed based on the hack order. That means.
No, Mr. Das.
Item 7.
This is something different. You are not on.
Yes. This IAS allowed. And Mr. Swapnil Paul, IAS is substituted in place of Sri Sumit Sathavan, IAS, as the contemner in the present case. So let a fresh memo of parties be filed by the applicant. In the registry within a period of 2 days. You get the details, you file this memo. Give a copy of that applicant.
Yes, sir. In case of 24/7. Item 8.
Delay of 23 days, madam.
State who accepts notice.
Yes, forest law.
Yes, Mr. So-and-so accepts notice on behalf of so-and-so, delay of 23 days. For the reasons stated, the delay is condoned. Give your slip, delay is condoned, the application stands allowed, the B to be processed and listed August.
12 August. Item 9.
There is the delay. Notice to private respondent, other respondent, government respondents accepted by the state councils. On requisites to be filed within a period of 2 weeks, both modes returnable August.
8th August, 5/8. Item 10.
Delay of 18 days. Or private respondent still have to issue notice. You appear for whom? Mr.
Goswami?
I am for the writ appellate now.
Accept notice.
Oh, sorry, Maluk. Next.
State of the SAM, then director, governing body, principal. Let notice be issued to response number 2 to 4 on steps being taken by the applicant within a period of 2 weeks, both modes returnable August.
7-8.
We'll do it. 18 days we don't hold back, but notice is to go.
But in the month of June, Maluk.
August. Yes, next.
Item 11 and 12.
Meet please, your lordship. Just one. Yes. Mr. Goswami. I think we'll allow this.
Maluk.
We'll allow this.
In fact, Maluk, in the main case, Maluk.
Of course, he was not there, but since some benefit has come from Supreme Court, whether it would go to him or not, he should not be stopped here.
Maluk.
This should not be
Subject
just
of
given.
Maluk.
We allow the application.
DP of National.
Okay. In fact, Maluk, in the main writ appeal, Maluk, as per your lordship.
Right, Mr. Goswami, we know. Otherwise, if the matter would not have been decided in Supreme Court and there would not have been some benefit accruing to the parties, we would have stopped him. But now if it is coming, we'll see whether it is to be given to him. We allow this application.
I have no objection on that.
You have no objection, we understand. But we are telling you our logic behind accepting it without any dispute, without any cavil. Yes.
Supplementary list for orders, item 26.
May it please your lordship. In this case, we have sought a clarification of the order passed on 27/11/2025. That lordship will find basically in page 94. Lordship has upheld our eviction process and whole exercise we have done, giving a green signal. But there were some observations which is now creating problem because the nearby hospital is being dismantled, and in this hospital, there will be large influx of patients. Already it has started. And we want this additional land of about 12 bighas for parking and various expansion of the hospital. The hospital was inaugurated on 15th of March. When this observation was given at paragraph 25, may I read it, paragraph 68. Taking note of the submission of the learned advocate general, the construction of the hospital is already completed and the land occupied by the appellant is required for future expansion and for ancillary activities. In our considered opinion, ends of justice would be made if it is provided that till such determination is made, no coercive measures shall be taken to demolish the existing dwelling houses of them. Now, the hospital has been fully functional and we need this additional because in our review application, we have annexed the documents. Lordship will kindly see page 98.
No, we accept everything.
Lordship.
Now kindly listen to two of the alternatives.
Lordship.
We are inclined to review this.
Lordship.
We are inclined to review this.
I am highly obliged.
But for reviewing this, we'll have to issue notice.
Lordship.
But the shorter way out is clarification of the order.
That will be better.
The option, we give it to you. The only reason is that hospital construction and its full utilization, full commissioning cannot be possible without the other buildings and without the access. We understand that. We are always for the completion of the projects which are for public, which are in public
interest.
So therefore, we are inclined to review this.
Lordship.
But before we review this, there is a legal compulsion of issuing notice on the others, which will take time. The other option is, kindly hear out the option because this would be on the asking of the learned advocate general.
Lordship.
The other option is that we clarify that 90 days to be counted from that period when you complete the exercise, whereafter you shall proceed ahead with the eviction.
That clarification is fine because till now, we could not complete because they have given us some affidavit. Because identical exercise is already done and that was put to challenge in the writ petition as well as in writ appeals. They were not entitled for land also. But again, we have redo and they have given us affidavits. Lordship has asked us to look into the matter
So
from the perspective of their.
have you initiated that exercise?
We have already done it.
So if you have initiated that exercise, why don't you conclude it within 90 days? We'll clarify that.
The thing is that once we close it by a speaking order, another round of litigation will start.
Your eviction process shall not be stalled.
That if that clarification is given, I have tomorrow itself we can close it because that affidavit which they have submitted that they are landless
Don't you do
only in the state of
Why
Assam.
don't you do one thing?
Lordship.
We will, the better option is conclude the proceeding. We keep it next week. You say that proceedings have been concluded, we'll say proceed.
Absolutely fine, Lordship.
That's a
Absolutely
better-
fine. Let the
that's-
matter come up on Wednesday. We'll close it by Friday or Monday.
That's a better way. In
Lot-
that case, otherwise, the legal aspect would be that without notice, we can't tinker with the order. Number one. Number two, clarification also means nothing unless you have completed the exercise. If you complete the exercise,
Come back to us.
90 days is not the cap that you don't have to wait for 90 days. Within 90 days, you have to complete it. The day you complete it, finish.
What was actually troubling us that once we complete the exercise, another cause of action will arise.
We will.
It will be a perpetual litigation line.
You complete it, come back before us. We'll keep this pending.
Lordship, let the matter be
That's
taken on Tuesday. On Monday, I will place, I will file the affidavit also with the completion order.
Comfortable date. You keep 1 week.
On Wednesday, then in that case, Lord.
Let this.
Because subsequent development has taken place here. That is the one ground where we sought review.
All right. When do you want it?
Wednesday next.
As prayed for on behalf of the review petitioner / state of Assam and others, petitioners / state of Assam and others, let this matter be listed in priority. Let this matter be listed on your days.
3rd June.
3rd of June.
Lordship, highly obliged, Lordship.
We are for completion of the public projects.
Because, yes, Lordship.
We are, that is, there can
There is
be-
paramount importance. That is a priority. Lordship.
We don't come in the way.
Highly obliged,
But,
Lordship.
see, some process has to be followed.
Lordship.
Now, because we have done that, it was accepted, that was not, so we will clarify.
In fact,
This-
in my submission that it is a completed an expansion. So at that time, we thought that expansion will take place after a few years. That was not the case, Lordship. In this special case,
You
because
complete-
Gauhati Medical
you
College is
complete-
being
you complete
dismantled
the
now.
process and leave it.
So every day there is a additional 3,000 inmates in the hospital, the footfall. Because the medical college is gradually closed.
That's,
That is within a 1 kilometer
that's a
away.
genuine demand. We will
Lord.
take it into account
Lord.
on Wednesday.
Highly obliged,
Tell
Lordship.
us that you have complied with the orders.
Highly obliged, Lordship.
Daily list for admission item 13.
Yes. Lordship. Lordship, here the matter relates to setting up of the pay of the senior lordship at par with the direct recruits. Lordship, here, the learned Cat had directed to refix the respondent's pay lordship at par with the entry pay of the direct recruits. The order is that pays lordship.
Now, please show us the civil CCS revised pay rules of 2008.
2003.
Yes.
Lordship, their pay was
No, just show us the rules, whether that is applicable, and show us whether the office memorandum dated 28/9/2018 issued by Ministry of Finance, whether it covers the case of the respondents. Then only we will pass a order of stay, otherwise not. See, they have been promoted to the post of assistants,
Assistant.
correct?
Under Rule 13, Lordship. they are
Whichever rule,
fixed, Lordship.
they have been promoted to the post of assistants.
Lordship.
Now, this memorandum of Ministry of Finance, Department of Expenditure, which decision is based on a CAT decision,
Get this.
which has not been questioned. It says that a promotee ought not to be paid less than the direct recruit if there is a provision for promotion. So this is what he wants. And this is what was allowed by the tribunal. Now, question is this, whether this observation, whether this circular is applicable to such persons or only those who were in the higher pay slab with higher grade pay of 4,600 prior to the 6th pay revision committee rules. That is the only question. You explain it to us, we immediately stay the order of the tribunal.
Lordship, otherwise the respondents were.
I have put you a
Yes,
simple question.
Yes, Lordship.
You either you answer or you will ask him to
Under-
respond.
Lordship, under Rule 13, these respondents' pay were fixed, Lordship, and the direct recruits' pay was fixed under separate provision, Lordship. There are two separate provisions for direct recruits and the promotees.
That's not the
And
issue.
now, Lordship, the OM dated 2018. This was passed in respect of the Lordship, TGT teachers.
Therefore, we are asking you, your understanding is very. On 1/1/2006, which is the cutoff date for 6 CPC.
6 CPC, Lordship.
Correct. So on that day, you can make an argument. We are not here to suggest you the argument.
Lordship.
Unless you argue, we are trying to ask you, pass from you, you don't apply your mind.
As per 6 CPC,
When
Lordship,
you have
there.
followed- when we have started giving you the hint, you take it.
Lordship.
On 1/1/2006, which is the cutoff date of 6 CPC, the respondents were in the pre-revised scale only.
Yes.
Correct? In the scale of 5,000 to 8,000.
Grade pay 42 to 100, Lordship.
Grade pay 4,200. So whether this new rule, new CPC rules, and whether the OM of 2018, would it apply to them? That's the question which perhaps you would like to raise here, which was not addressed by the tribunal appropriately. So the only that OM will apply only to posts that were in the grade of 6,500 to 10,500 on 1/1/2006. Only those persons occupying that post with that pay slab were entitled for a grade pay of 4,600.
But
That
the
is the issue.
respondents were not in the grade pay of 4,600, Lordship. They were 4,200.
If you,
Therefore, this OM was not applicable to this.
how do you say that? Show from the rules
Lordship, as
now.
per 2009 OM, Lordship, in our written statement also, we have set it, Lordship. Lordship, my permission.
You will have to show it from the ROP.
Lordship. RP Rule 13, Lordship, otherwise applicable to.
Yeah, what is your response?
Lordship, actually, many of the documents which were part of the OA written statement, and in fact, the rejoinders are not enclosed with the this particular.
Is it necessary?
So that is why, Lordship.
Is it necessary?
that
Is it compulsory for a person to file a petition to enclose everything what happened in tribunal?
that will be
Which rule says so?
no, that will be necessary to show
So you supplement it, you file your response to this petition.
because I was already granted 4600. That is evident from their pay fixation order.
That is,
And that document has not been enclosed.
that is the order which they want us to strike down.
No.
That is the order which they want us to strike down.
That order is-
You got it only on the orders of the CAT, no?
No.
Then
Prior to order of the CAT, I was already receiving 4600 upon my promotion to the.
then you are entitled.
Yes.
Then you are
There is pay
entitled.
fixation order to that effect. Pay fixation order.
So respond to this
Yes,
petition
yes.
and say that
They have suppressed my
this
rejoinder.
statement is incorrect by the union.
Yes, the entire rejoinder has not been.
Okay.
enclosed.
समझ गया.
460 was not in dispute, Lordship. I was already granted. Based on that, CAT passed the order.
The petitioner / Union of India, the petitioners / Union of India and others have challenged the order dated 22/5/2024 passed by the Central Administrative Tribunal, CAT Gauhati, whereby a direction has been issued to grant to the respondents entry pay of a direct recruit assistant which is at rupees 12,540 in pay band 2, with grade pay of 4,600 from the date of their promotion to the post of assistant from 14/12/2011. It appears that the respondents were initially appointed as lower division clerks in the year 1991, and by promotion they were and through promotion they came to occupy the post of assistants,
UDC lot.
upper division clerk.
Oh, in 2000 and 2001.
2001 is they are not referring to.
And thereafter is
Assistants
in 2011.
11.
on 13/12/2011.
And then pay fixed lot.
32.
Enforced.
Based on the provisions contained in CCS bracket RP rules 2008 and office memorandum dated 28/9/2018 issued by the Ministry of Finance, Department of Expenditure, indicating that if any post has a provision for direct recruitment, the promotees should not get any less pay than the direct recruits appointed after 1/1/2006, the respondents approached the tribunal for necessary direction in that regard, regarding the fixation of their pay and the grade pay. This was contested by the Prasar Bharati / appellants herein on the ground that the respondents are promotees and not direct recruits, and that their pay was fixed under Rule 13 of CCS bracket RP rules of 2008. On 1/1/2006, which is the cutoff date for the 6th CPC, the respondents, according to the appellants, were in the pre-revised scale of 3,000 to 8,000 and not 6,500 to 10,500, thereby entitling them to a grade pay of 4,200 only and not 4,600. It was further asserted by the appellants herein before the tribunal that there was no appointment, there was no direct recruit assistant appointed in the department either before or sometimes after 1/1/2006, and therefore there could not have been any pay anomaly. The other limb of argument on behalf of the appellants before the tribunal was that the assistants in Prasar Bharati would be under deemed deputation a subordinate cadre and not par with the assistants in Central Secretariat service. The contention of the appellants here is that with the grant of grade pay of 4,600, the entire promotional hierarchy would stand disturbed, and there will be a huge financial responsibility on the state in connection with huge financial responsibility on the state. What is your name?
GJ Sharma.
Mr. GJ Sharma, learned advocate who appears for the respondents, submits that even before that the respondents were getting the grade pay of rupees 4,600 from before, which fact has not been stated by the petitioners in the present petition, in the present in the by the petitioners in the present writ petition. To stop. In fact, the documents which were the documents on which decisions were taken in the tribunal have not been made part of the record. To stop. He therefore submits that he be given an opportunity to bring all those documents on record by way of affidavit / reply affidavit to this writ petition. Let this matter come up for consideration in August. In the meantime, the reply affidavit on behalf of the respondent shall be filed positively with a copy in advance to the counsel for the petitioners, to rejoin in case so deemed necessary.
August. 12.
Item 15 and 16.
Right.
In 15, Your Lordship, we have challenged the cabinet decision, Your Lordship, dated 5/2/2025.
They have come out with cabinet decision also.
Cabinet
To 5/2.
2025, that Your Lordship we have not got the copy, Your Lordship. But in the affidavit filed in the item number 16, Your Lordship, they have submitted that on the basis of a cabinet decision dated 5/2/2025. They have kept the implementation of 12(1)(c), Your Lordship, into the vernacular schools, Your Lordship. That we have put to challenges. It is completely ultra virus of the act.
You can't call it ultra virus, first of all.
Lordship.
The reason is that it is not as expensive as RT, as Right to Education Act says.
Lordship.
It is not as expensive. So that leeway they have no distinction has been made in the Parent Act, in the Central Act with respect to vernacular or
Lordship.
We understand the logic could be a warped logic.
Lordship.
That for the promotion of Assamese language and all. But you can't possibly call it ultra virus because
Your Lordship,
that power they have. I mean that's this in the concurrent feat. So they have come out with a decision. But this is a cabinet decision. There is no legislation.
Lordship.
Where is that decision?
No, that's Your Lordship. They only said, Your Lordship, in their affidavit that there is a cabinet decision dated 12.
Where is that cabinet decision? Could you lay your hands upon it?
No, Your Lordship, we have not.
Mr. Mazumdar.
My lord, they have challenged it already. And my lord,
They have challenged it in
They have challenged only on the basis of their affirmation in affidavit.
made by you in your counter affidavit.
yes, my lord. Yes. If your lordship
You
goes,
tell us whether there is a cabinet decision.
there is, my lord. We have
Okay,
specified.
show us a copy of it.
My copy is not available. My lord,
Mr. Mazumdar, then how do you answer the challenge?
my lord, this, in fact, your lordship indicated they have come here with a grievance. The Right to Education Act 2009 was not implemented in schools other than vernacular. My lord, lordship will give me 1 minute. I have understood, my lord.
I will give you not 1 minute, I'll give you 10 minutes.
My lord.
But if you are proceeding on that assumption, if you are taking the argument to that point, then perhaps it will not be good.
No, I'm not arguing that, my lord.
You say that initially they have come only for implementation of the Right to Education Act. Now they can't be permitted to say that.
No, I'm not arguing that. I'm simply saying that despite your lordship's indication earlier, they have challenged the cabinet decision only now. And in fact, my lord, if your lordship goes to
The net result is that only, no? Full
No, my-
implementation means what?
lordship will kindly have a
So
look at-
therefore you give us the reasons.
my lord.
We will.
Not only that, my lord, we have taken a different stand because we know, my lord, at least I know, my lord, it has to be implemented without any discrimination on the ground of religion. And we have just yesterday we have written, we are yet to get a response, which will give us a couple of days. I think in the affidavit, we already indicated that.
That
Earlier
couple of days has been going on since 2021.
No, you have challenged it
Your
only
Lordship.
today.
That's different. Your Lordship,
You have
kindly
challenged it
see
only.
this judgment, Your
Cabinet decision was never challenged.
Give a copy to her.
Yes.
That I will take, your lordship may kindly go through this judgment, your lordship. Recent judgment of the Honorable Apex Court, your lordship. How the Honorable Apex Court has interpreted section 12, your lordship. Para 8. If your lordship permits, I will read your lordship. Why it is important, your lordship, not to confine it to only to vernacular medium schools, your lordship. May I read you?
Yes.
Properly understood, this statutory design is normatively ambitious. It envisages elementary education for all children across the spectrum of class, caste, gender, and economic position in a shared institutional space. It makes it possible normatively and structurally for the child of a multi-millionaire or even a judge of the Supreme Court of India to sit in the same classroom at the same bench as the child of an auto rickshaw driver or a street vendor. This is the manner in which Section 12 seeks to concretize the constitutional principle of fraternity alongside equality and liberty. A correct appreciation of fraternity must displace the traditional but mistaken view, often repeated in constitutional discourse, that it is not an enforceable value. Our constitutional jurisprudence compels us to read fraternity as a value requiring the state to structure institutions that nurture coexistence, mutual respects, and a sense of common membership. Unlike equality and liberty, which are frequently framed as an individual rights, claims fraternity is relational. It operates through institutional arrangements that enable individuals to lose suspect identities based on caste, class, and other hierarchies to form a solidaristic bond. In this sense, the 25% inclusion under Section 12 is unaided neighborhood school is not an isolated welfare measure, but a vehicle through which the constitutional commitment to fraternity and development of the child as recognized in Article 21A and Article 39F is sought to be realized. This is the purpose. If this is the purpose, how can they keep the unaided English medium schools or other schools out of the purview of this Section 12(1)(c) or also? That they cannot do. And that is what they are doing also. And your lordship may kindly see this note, your lordship, we have prepared how they have been dealing with this, your lordship. This note will reveal everything, your lordship. Yes. This is in PIL 13, prepared in connection with PIL 30, your lordship. An act, your lordship, brought in the year 2010. Now, after 16 years, your lordship, you are filing petitions for its implementation.
Mr. Mazumdar, you need to go through this judgment. Apart from the contours of Section 12 of the RT
21A.
21A,
Article
the
21.
SOP in Delhi
Ma'am.
has been taken note of by the Supreme Court. Supreme Court says that no, every state need not follow that. It's only guidelines. It's not in the nature of the legislation. But the purpose of neighborhood school is that it must be so egalitarian that in the same civic space, I mean, very pithily it has been stated that it occupies a public space, and that space should not shut out the child of an auto rickshaw driver and promotes judge of a ward of a Supreme Court judge. I mean,
It has gone to
yes,
the root
yes,
of, root of the
to that
matter.
extent. Now, can you say that you would admit them only in the vernacular medium mass schools?
Before that,
Neighborhood schools, all schools. In fact, you have to come out with a very strict directive through your education department that every school should mandatorily, I mean compulsorily, otherwise their license to run the school would be cancelled. They have to register themselves on the portal issued by you, correct? And they have to verify, they have to advertise and make it public that 25% of the seats are so many. On this basis, we shall be taking admission of disadvantaged group of children. The money shall be paid, if it's a private, money shall be paid by the government.
I don't. Lordship, can we have a look at what is the stand we have taken till now? Lordship, just have a look, madam.
We are happy that you are at least, you have understood the issue and you want the cabinet, the cabinet to reconsider.
Madam, we have taken a specific stand in the affidavit that we filed in the other pending PIA. That for revisiting, my lordship, just have a look at the paragraph.
The letter speaks it all. We are happy.
The affidavit, in the affidavit last we
Affidavit
filed.
also you have said. We are happy.
May I read just one
Now,
paragraph?
Till what? Mr. Mazumdar, if there is a doubt, then you read.
My lord.
If we are doubting your statement, then you will read. We are not doubting it. We are expressing our happiness. At least you have understood the issue and you are not taking it as an adversarial litigation.
That's what
We are happy at this. Now you tell us, when do you expect this review?
Yes, madam.
We will want this, a timeline.
Madam, what?
You can't keep it pending. Now
No.
elections are over. Number two,
Yes.
this financial year is, this academic year is gone. It should not be for the next academic.
Madam.
Now, three things you have to ensure. Apart from the review of the cabinet decision, you can't go beyond the cabinet decision.
Yes, that is why it has to be revisited.
We understand. We can, only day before yesterday did you not see that judgment?
Madam.
Taking the stand of the government, an officer cannot be punished for contempt.
Yes.
Personal contempt. We understand. We don't need any espousal of law on that.
Madam.
The question is this. Now, first you have it revisited because it is not in tune. Otherwise, they will challenge it and we shall act accordingly because we have the Supreme Court judgment. We have the other, correct reading of the RTE Act. If you review it, there is no necessity for us to enter into that space. Number one. Number two, before that, even for this Assamese medium school, you have not made it compulsory for every school to register. Making a statement that schools must register is not going to do. You have to add it by saying that failing which,
otherwise,
some
consequences will follow.
adverse steps shall be taken. Adverse view shall be taken.
That has to be done.
And cancellation of the license to run the school also would be effected. You have to do this to ensure compliance. Number one. Number two, they have to specify the number of seats available. 20% of the seats available. 25%. And these are the number of seats available. This is the timeline within which admission shall be taken. It has to be notified in 3 dailies. 2 local dailies, 1 English daily. This is, you kindly go through the SOP of Delhi. We are not that every time SOP of the Delhi is better, but then they have made it, it has been taken note of by the Supreme Court in its judgment with respect to this only. And you can take light from there because all stages have been delineated, especially in this judgment. Now, when? Correct. We are happy that you have taken it in the right spirit. You are not opposing it that no, we will only do it.
The act is very clear. There is no escape. Act is very clear.
There is no escape. That is one. You also desired to have it done as a state.
Yes. In the affidavit, the government itself has taken a stand that we are going to revisit it. It is mentioned in the affidavit. In the last affidavit, in response to their affidavit in the other case, we have specifically mentioned the matter is proposed to be placed before the cabinet for revisiting the state policy.
There should be
and it has already placed.
Mr. Dilip Mazumdar, Learned General, submits that up till now, the admission to the disadvantaged group of students was being facilitated in Assamese/vernacular medium schools, which was pursuant to a cabinet decision. However, in view of the judicial pronouncements with respect to the contours of the RTE Act and the concept of neighborhood school, the matter has been placed before the cabinet for a revisit so that admissions are made of such students even in schools which are English medium and not vernacular medium. Mr. Mazumdar has further submitted that he shall communicate to the department regarding a detailed SOP to be formulated in that regard, which will ensure compliance by all schools for registering their institutions on the portal and notifying the number of seats available in newspapers with wide circulation. A help desk also shall be maintained at all such schools for necessary information in case so demanded by the targeted groups. Mr. Mazumdar, learned additional advocate general submits that a review of the cabinet decision is expected in a short while. Which shall be communicated to the court by the next date, hopefully. Which shall hopefully be communicated to the court by the next date. Re-notify. We give you 4 weeks.
My lord, because it goes to 2 other departments before going to the
4 weeks, 6 weeks. What do you want?
6 weeks.
6 weeks. Now the efforts of Mr. Thakur and Ms. Verma, it appears to be bearing fruit now.
This has been the continuous pattern in the.
That's why it has closed
Just
down.
look at that list of dates we have just submitted.
That's all right. Now you must,
I just want to make.
at some point of time, Ms. Verma, you must trust something which is there on record.
Lordship, we have been trusting this court, we have been trusting the respondents for 3 years. And for 3 years, each time they have a new pattern before this court. Lordship, please.
No, this time no pattern.
No, you,
I just want to place 2 things.
But
before
why
this court.
get into that? Now, when you say,
Lordship,
why get into that, we'll do it on the next day.
Lordship,
When,
6 weeks would be too much, Lordship, 4 weeks.
2 departments have to be consulted, necessary
It goes to
instructions.
the legislative department first, then to finance, and then to the cabinet. It's a long.
6 weeks.
secret.
Let that be the last date when you come out with a proper, when you come out with a fresh affidavit, that now this is being done henceforth.
Lordship, I just want to make a small submission, Lordship. 23, when we filed this petition, order dated 11/9/2023. They gave the court assurance in 2 weeks' time the portal would be ready. That order is before Lordship. Again, order dated 29/2/24. Last chance was given to the education department to start the portal for the academic year 23/24. It never happened. Again, order dated 3/10/2024. They had a cabinet meeting, Lordship, where they placed before this court that a comprehensive portal undertaken by 21/11/24. Whether it is the same portal or are they coming up with a new portal? This portal was also placed before the court, and till date we have not seen the light of it, Lordship. So how many portals do they need for one act, Lordship? And how many portals do they need to implement this RT Act?
Mr. Mazumdar, we are keeping it on 26th of June only to ensure that cabinet decision.
Yes, madam. Now the major issue is cabinet decision.
Cabinet decision is taken, and hopefully if you
It
want
should
2 further weeks, we'll review it on that day. So let that be on 26th of June.
In fact, they placed it before this court that the portal was operational. That is the reason I'm really worried, Lordship. How many portals do they need? Why they keep changing the pattern, the design of their submissions before the court? Everything is there in the orders and orders of this court. They have placed it in this court. Courts have passed various orders. I've made a comprehensive note today before
Mr.
Lordship.
Mazumdar, today almost had a cakewalk with the court for the reason of the letter written by Mr. Khatnia to the department.
We are
Otherwise-
aware,
otherwise we were-
I am aware, but two things are
Otherwise,
there.
we
My
were
learned friend is, my learned friend is placing certain things to influence the court. Madam, one thing.
No, where is the
Madam,
creation of
let me be very
influencing the
clear.
court?
Madam, I am not.
These are all part of the record.
I am not in the habit of appearing in a case where I have to simply ask for time. I want to argue on merit. I'm just making it clear. So let me. Madam, so far as the cabinet decision is concerned, despite being informed by an affidavit earlier, they have filed the writ petition now challenging the cabinet. Can they argue anything against that cabinet decision?
No, they can argue, but how can you move beyond?
And they have not placed the
No, this-
cabinet
Mr.
decision
Mr.
before
Mr.
this honorable
Mr.
court will
Majumdar,
get your
Mr.
lordship.
Majumdar, forget about cabinet decision. Tell you whether the vernacular, all schools are, all portals are available.
My lord,
Please
there-
tell us that.
my lord, there-
Tell us that.
My lord, there, what has happened, my lord, in the affidavit, we have made it clear that certain schools have not complied with certain
Why are you
requirements.
Mr. Mazumdar, tell.
That's what, my lord, that's what I
Tell
said,
the-
my lord. Even
tell
for
the
that also,
schools.
we have to take action,
Tell the education department
my lord.
that we know how to make them comply.
I have,
Schools can't afford to be non-compliant.
my lord, I
They
have.
can't afford to be non-compliant.
The purpose of writing this letter yesterday is to communicate to them everything. Over phone, my lord, my learned friend has informed everything. This is the position of
That
it.
letter is something different. We are asking, notwithstanding the, cabinet decision as it is, without the review.
Right.
Now, all vernacular schools, can you make a statement that all schools have registered?
No, man,
You can't.
no,
So therefore, you don't even require a cabinet review decision
for that.
for that.
Yes.
Now, you must ensure where is the letter of your director of education or secondary education, whichever post is the head, who controls it.
My lord, lordship has given some time. I'll come up with all these replies. My lord, your lordship will just.
See, I can tell you an example from the state of Bihar where the education department was being managed by one of the most effective IAS officers, and every school became compliant. Otherwise, FIR used to be registered that you are violating the norms and you're guilty. That let you decide it's a criminal offense, something like that. Some drastic step like that was taken
To compel them.
Yes. So if you're in a position to
Well,
say,
I'll ensure that.
so we are giving you 4 weeks. On 26th, we will review what is the updated status. We might not ask you to, we might not ask you for a final decision. But then on that day, you must tell us any step taken by the department for ensuring compliance by all the schools, number one. And number two, whether it has been put in the agenda of the cabinet for review of that decision.
In our reply, your lordship, we have said, your lordship, we have found 7 or 9 schools, your lordship, who have registered. Only, your lordship.
That's bad.
Government has been.
That's Mr. Mazumdar, that is bad.
But I'll come up with all the replies.
But
why?
It only speaks badly of your position.
But that's what I'm finding very
Position
difficult.
is a welfare state. The session is on. If we don't consider the regularity of the session of our children, what are we doing here? What are we doing?
Right.
Anyway, on 26th, Mr. Mazumdar, you shall be here.
Right.
And you will tell us what steps have been taken by the department.
Absolutely.
You fix, don't keep changing portals. Otherwise, they'll say that we did not know, we knew.
No.
You make them compliant by whatever means. And I think you have the authority of the Constitution. You have the authority of the Constitution. You're not doing any.
Yes, yes. Act is very clear.
Go soft on them.
Yes.
That's what we expect of you. Mr. Mazumdar, you
My
talk to the authorities today only
Man.
and give us the updated report. Okay, next.
Lordship, my last submission, whatever I have submitted before this court is on the basis of the orders passed by this court. Nothing to influence lordship. I am not so powerful to influence anyone.
Swarma, don't take statements of adversing lawyers.
The senior counsel.
No, senior counsel has been, see, it is a respectful submission. Don't take it otherwise. And many a times, if it doesn't happen, we will also not get the spice to remain agile. Otherwise, we'll also doze off. Let it happen. This is the beauty of a courtroom proceeding. And you don't have to take things very seriously. too hard. I mean, we are not.
Take it as a
Have we told you?
compliment.
Have we
What should
told?
I take it as a compliment then?
Yes, yes. Have we told you that you're influencing the court in a different way? We have not. So other side has the right to say. आप उनके बारे में बोलेंगे ये इनके बारे में बोलेंगे doesn't matter. As long as you don't transgress the borders of civility.
I did not mean anything which is not permissible inside the court.
Item 18. Deeply obliged.
May it please your lordship. This matter may kindly be taken up after some time, my lord. My senior Miss Ibuya will appear in this matter.
May I please your lordship?
Yes.
Am I audible, my lord?
Yes, yes, you are visible, audible, everything.
My lord, this matter pertains to that BTAD students.
A prayer for some accommodation has been made because of the inability of one of the lawyers to be here. The
My lord,
BTC.
can it be on in that case on 1st of June? Because our ages are also increasing day by day.
1st of June would be difficult. We can keep it on 8th of June.
8th of June. Fine, my lord.
At the request of, you're making request on behalf, on whose behalf?
Miss Ibuya, senior counsel for BTC.
At the instance of, at the request of the standing counsel BTC, the matter is adjourned to 8th of June.
Value.
Item 19.
Mr. Chaudhary.
Please, your lordship, this matter also relates to service pension, but it is the first service pension. On the other way, it was the second service pension.
Now, what do you have to say to this?
Here, the period remains the same, 15 years. As per the rules, condonation of 6 months. However, interpreting the rules, the Supreme Court has granted up to 1 year. Now, here the deficiency is more than
1 year, more than 1 year, it's 1 year, 1 month.
1 year, 1 month.
It's 1 year. Why do you want to leave your own employee, your own officer, totally high and dry?
That, lordship, in fact, if your lordship opens that door, it will open floodgates.
That has been that fear and the law, and these are two different things. I mean, the tribunal has awarded it.
Further,
Why does it interfere?
there would be another aspect of the matter, that is the respondent herein approached the tribunal after 33 years.
When you do it for second pension, why not for first pension?
The second pension till 1 year.
That's correct. Second pension also, they say, I mean, my view before the Supreme Court judgment was that second pension also has to be, I mean, it has to be in strict compliance with the period.
Yes, lordship.
But it can only be relaxed under a situation when he doesn't get a pension in the first service.
Lordship.
So he should not be left without pension.
Lordship.
So unless that condition is satisfied, I had not been granting, condonation of the shortfall in other jurisdiction also.
Lordship.
That was my view, but that view has not been found to be correct by Supreme Court. Supreme Court says that these are two distinct things. They don't even question, they don't even like to find out whether he's getting one pension.
That is not there.
That is not there. So why not this? If second pension, the Supreme Court is so indulgent, why not this? And 1 year, 1 month.
In this case also,
6 months and up to 12.
in this case also, Lordship, the more than 1 year, the Supreme Court has condoned the same case, Lordship, which they considered, agreed that at before the tribunal, they agreed. Then after 3 years now, they have filed this petition.
That agreement, lordship, if your lordship
And
will come to
Lordship,
the tribunal.
paragraph 9 of the judgment, Lordship, I have faced from 9 onwards. They are also delay of more than 1 year, not for 1 month was there. Paragraph 9.
No, don't talk about 3 years thing. You came to the court after 33 years.
Yes, Lordship. Yes.
And you're questioning his 3 years.
Yes.
Up to here.
That's the answer.
13 years, 10 months, but with this.
No.
No, that is the demand.
Okay.
You have given him the areas, the tribunal has directed for areas only for 3 years.
3 years. only.
3 years.
That's correct, that's same thing.
That's
That's
correct.
not from 2001.
Not from the lordship.
Why do we interfere?
Because lordship, the decision of Pharma, which was relied upon. Now, that was from a judgment of the, it was an appeal from a judgment of the Bombay High Court. And the rules therein was the Navy rules. And the Navy rules had a peculiar situation where normally there can be a condemnation for 1 year, but if he gets discharged at his own request, that 1 year will not be effective.
Let's see paragraph 125, the pension regulation of Pharma.
I have quoted it, lordship.
You've quoted it.
I have quoted it, and page 9.
Page?
Page 9.
Is the perimeter of the Navy regulation.
Mr. Tabildar, when you find the court to be in your favor, why do you have to respond? When the court is, giving indications of a favorable order, why to interject?
Sorry.
Where is it? Page 9.
Page 9, lordship. 125 of the pension regulations for the Army 1961 so dealing with condemnation of deficiency in service for eligibility to service reservist pension stipulates that except in the case of an individual who is discharged at his own request, in this case at his own request, an individual who is eligible for special pension or gratuity under regulation, an individual who is invalidated with less than 15 years of service, deficiency in service for eligibility of service pension or reservist pension, or gratuity in lieu may be condoned by a competent authority up to 6 months in each case. Now, by judicial interpretation, lordship, so far as the Navy Act was concerned, there was a decision of the Bombay High Court which was not challenged by the authority, and for that reason, the order in Parmar came.
Where is that judgment which you gave the second pension?
I have got a copy of this order passed by your lordship.
Perfect. Now, Mr. Pavin, that we may not disturb the decision of the tribunal, but then after 33 years you go. In the first instance, we would not have done it. But it's very difficult to accept this. Otherwise, it is unnecessary sympathy shown to you. 33 years you did not have pension and suddenly you got up and opposed the tribunal. 3 years, 5 years, 10 years, 33 years, 3 decades. How old are you? He must be in his 90s. Or maybe in his late 80s. No, we are not interfering.
May I, sir? Today I am appearing for the first time after promotion of service. Then Lordship, I will place the Lordship some judgments also because Honorable Supreme Court even 42 years delay in the army armed forces. Even 42 years. So
we are not going by the judgment of the tribunal. We are not interfering with it. But in the first instance, we would have rejected it in no time. Suppose we were the members of the tribunal, we would have rejected it straight away. 33 years is a long time. Amen.
Tribunal order is the page 17, Lordship.
The petitioners. We have heard Mr. R.P.D. Chaudhary and senior advocate. Mr. Deputy Solicitor General for the petitioners and Mr. Babilda led an advocate for the respondents. The challenge in the present petition is to the order dated 35/2022 passed by the Armed Forces Tribunal, Regional Bench Gauhati in OA number 27 of 2020, whereby relaxing the minimum service period for qualifying the respondent for grant of pension. It has been directed that the respondent be paid pension within a period of 3 months from the date of passing of the order by the tribunal. And since the order was being passed after 33 years of his discharge from service, so the arrears would be restricted to 3 years prior to date of the filing of the application. That is 29/6/2020. Mr. Chaudhary, let me senior advocate / Deputy Solicitor General submits that no reason has been given for such condonation after 33 years of the discharge of the respondent. The respondent had joined Indian Army sometimes in the year 1973 and was discharged on 30th of June 1987 at his own request after completing 13 years, 11 months and 5 days of service. He had sought voluntary retirement because of some domestic problems. Under the pension regulation for Army 1961, the minimum qualifying service for pension is 15 years. Since he fell short of such qualifying period of service, he was not granted any pension at the time of his discharge. So, It appears that after 33 years of his discharge, the respondent approached the authorities for grant of pension, which was rejected. Mr. P therefore approached the Armed Forces Tribunal, claiming that the shortfall in his service for grant of pension to him ought to be condoned. The tribunal, relying on Union of India and another versus Surrender Singh Parmar, 2015, 3 SCC 404, condoned the shortfall and directed for grant of pension to the correspondent, but restricting the payment of arrears only from 3 years prior to the filing of the petition before the armed forces, before the AFT, before the tribunal. Mr. R.K.D. Chaudhary, Mr. Chaudhary, learned senior advocate for the petitioners, has submitted that the facts of the case of Surrender Singh Parmar Supra is distinguishable because it dealt with Navy pension regulations, which are a specific regulation. No, it's distinguishable because it dealt with Navy pension regulation. The Army pension rules is governed by the relevant regulation, bracket paragraph 125, which explicitly prohibits the condonation of shortfall for persons discharged at their own request. We have examined paragraph 125 of the regulations, wherein there is no such explicit proscription in condonation of delay, in condonation of the shortfall in the period of service for grant of pension to a discharged employee. Though we do consider that, though we are a bit surprised that such interference was made by the tribunal after such interference was made by the tribunal only even when the respondent had approached it after 33 years of discharge. But considering the fact that the shortfall is condonable and that the respondent is now at the fag end of his life, we do not wish to interfere with the order passed by the trial. The petition stands dismissed.
All right.
We had to say this because the tribunal should not say that in 33 years after election come after 40 years we'll do that. So we say that we are not doing it for this reason.
All right.
Item 20.
May it please your lordship. My lord, I am appearing for the first time today for respondent number 4.
Yes.
If your lordship permits me, my lord, then I can bring a short affidavit on the.
Because my tenure is up to August, my lord. By this time, if I ultimately succeed also, it will be patient, the operation will be successful, patient will die.
In fact, my lord, I find that your lordship had given leave to the respondents number 1, 2, and 3 to file a response. But perhaps that has not been done. But I am appearing for respondent number 4 for the first time today on notice.
We keep it next week only because of the short time that Mr. Roy Chaudhary has. Short lifespan that he has.
Yes. Otherwise, my lord, otherwise I can argue the matter. But then since some factual allegations are there.
Mr. Datta, learned senior advocate who appears for respondent number 4, seeks a short accommodation to put in his response to the present appeal. Let this matter come up for consideration on next Friday. Next
5-6.
In the meantime, the other respondents also may put in their response, if so.
Deeply obliged.
My lord, can it be the last opportunity, my lord, not more?
No, my lord, I
Remind us, you tried that. Don't remind. You remind us that day that your thing ends. My brother remembers in such cases. We don't write that anything can happen to anybody. I mean, suppose the prayer for adjournment comes from you. What do we do? So we don't bind ourselves. There should not be an ironclad, cage. Next.
Item 25.
Very Mr. Mohan. That day he was. I was only wondering that today, Mr. Mohan. Yesterday he was opposing the adjournment. Not yesterday. Or the day before, my lord. Yes.
No, my lord. If I may submit.
Yes.
My case before the Honorable Singh was very simple, my lord, as a writ petitioner, that both me and the appellant participated in the selection and I scored more marks. Therefore, I should have been selected and appointed. That was my case. Now, my lord, the appellant came up with the plea that I do not belong to that particular, my lord, center. That is the, my lord, issue. Now, what happened, my lord? Now, the appellant is relying on page 172 to bring home the fact, my lord, as it is, that I do not belong to center number 23. That is the case. Now, my lord, so far as this document is concerned, at page 172, this was not before the, my lord, Honorable Single Judge when the writ petition was decided. This document was annexed with the, my lord, review petition.
Yes, yes.
That document was a part of the review petition and filed by the appellant, and the review was also dismissed. The Honorable Single Judge held that, my lord, we have already decided the issue. This is, my lord, an appeal in the guise of a review, and my lord, review application was rejected. Now, if your lordship comes to page 172, because, my lord, I want to meet the point my learned friend was, my lord, working on.
Page 172.
172. This is in vernacular, my lord. Here, against, my lord, this is, my lord, description of the integrated.
My brother will be telling you what is.
The only thing it says, my lord, that this integrated child development project, the Anganwadi center is Pazibora Poo, that belongs to 217. And, my lord, at page 173, my name appears. And therefore, I do not belong to 23 and I belong to 217. That is the, my lord, precise case of the appellant. Now, so far as these documents are concerned, as I have already stated, these were, my lord, a part of the review application only, not in the, my lord, original writ petition.
What is your name? Name of this respondent number one?
Hongita. Hongita. Hongita's name appears at serial number 2. At page 173. Now, so far as these documents are concerned, which are a part of the review application, my lord, the government has not filed any affidavit to, my lord, either, my lord, agree to the genuineness of these documents or, my lord, against it. But then, my lord, this report, my lord, keeps on changing. If your lordship kindly permits me to place one document, my lord, to show that.
Before that document, you please come to page 205. Can we go beyond that?
My lord, against this page 172, I want to draw your lordship's attention to 2 documents filed. That your lordship will find at page 76 and 78.
You please read this aloud for the consumption of the court. and then we shall look at all documents.
That is the my lord affidavit of the my lord government.
Yes.
Paragraph
Who
three.
would certify?
My
If the advertisement is misleading, who will certify? The government will certify.
Government.
So look at this.
The deponent respectively says that the advertisement was published by the respondent number 6 on 18 to 2019 for filling up the vacant post of Anganwadi worker in the Porua Pazipara Poop Anganwadi Center, which is actually 23. The 217 number Pazipur Poop site Anganwadi Center is a different Anganwadi Center under the Anganwadi ICDS project where Srimati Podumi Besbura is serving as an Anganwadi worker. And the name of this Anganwadi Center is not mentioned in the said advertisement dated 18 to 2019. The advertisement dated 18 to 2019 has no connection with number 217 Pazipar Poop site Anganwadi Center. Now, my lord, your lordship will kindly come to page 76. This is the document, my lord. In fact, the document starts from page 75. This is an RTI reply, which has a part of the my lord writ petition. Page 75 shows, my lord, this is the RTI reply given and these documents are annexed. Page 76, your lordship will find updated applicants for Anganwadi worker for interview under Nalbari ICDS project. Now here your lordship will find the last, my lord, entry, Porua Pazipar Poop site. Here, my lord.
Last entry, where?
At the bottom, my lord. Serial number 4. Serial number 4. This is the center, Porua Pazipara Poop site. My lord, the name of the petitioner appears here. And also, my lord, the name of the appellant appears. My lord, both the appellant and the respondent number 1 at serial number 1 and 4. Now, this is a document which was before the my lord selection committee. Then your lordship would come to page 78. After this list was prepared for my lord accepted applicants, that means, my lord, both me and the my lord appellant, they were from the same my lord the center, and which is my case also, my lord. Then if your lordship comes to page 78, thereafter, my lord, not accepted list of Anganwadi worker under Nalbari ICDS project. Here your lordship will find the last entry at serial number 9, Porua Pazipar Poop site, Pinky Besburua, wife of so and so, so and so. So that person has been excluded from the list. And my lord, this lady, he is my lord working in my lord another my lord that 217. Therefore, my lord, this is the document before the selection committee to show that, my lord, both me and the appellant, they are under the same center. Under the same center. And my case is that, my lord, I secured more marks, therefore I should be selected. That is as simple as that, my lord.
Can you see?
And this, my lord, this document, my lord, that 217 was, my lord, keeps on changing. If I may produce one document to show
Just
that.
give us a minute now.
My lord. Now it is against 23, my name has been shown. So these are some documents, my lord, which your worship will see the weight of that document. Selection committee had this page 76 and 78 before it. And the my lord, selection records were, my lord, placed before the honorable single judge. And honorable single judge found that both of us belong to the, my lord, same, my lord, the same center. And I secured more marks, and therefore, my lord, the honorable single judge has held that, my lord, I have to be appointed. And the center is just, my lord, in front of my lord residence. I have given a respect to show that may not be, my lord, very necessary for your lordship to consider. But the fact that, my lord, we are in the same center, that is the stand of the government as well as, my lord, my lord stand. And, my lord, I secured more marks.
He's on the document disputing your survey area based on that paper, 176, nothing more.
And government has not said anything about that document also.
Government has not said anything about it. You're right.
But then, my lord, these are the documents, okay, 76 and 78, which are before the, my lord.
Correct, correct. And so it was decided, correct. Correct.
And these are the documents before the, my lord, the selection committee, 76 and 78.
You are at present working, no?
I'm working, my lord, after the judgment, my lord, I have been appointed.
Yeah, and you have got more marks.
I have got more marks. That is not disputed.
We'll file this affidavit from government that regarding your survey area, your residence, whether within that 23 laws.
Yes, Mr. Ma.
Madam, may I submit now, madam?
Forget about
May I submit now?
Just a minute.
Yes.
They are not now concerned with 23 or 26.
Madam, kindly, let us not rely on page 171 for a moment. So my learned friend says, my lord, that this is the only document which says that she belongs to 217 and I belong to 20. I belong to 23. Correct, my lord? So far what I've understood, my lord. And this is for the first time my learned senior friend has said, my lord, is it his claim that he belongs to 23? Is it the claim of the respondent that she belongs to 23? It has not been pleaded in the 3 rounds of litigation, my lord. Now, if I may,
Interfere, my lord. The center number was never there.
Yes, it was
In
never
the
there.
advertisement, the center number and the advertisement is not on.
My lord, may kindly come to page
I said,
73
my
for a
lord,
moment.
I belong to this village.
Page 73, kindly, for a moment. Let us not rely on 171. Let us rely on the statements made by the respondent number 1. Page 73. It was an RTI filed by the respondent number 1 asking the reasons why her candidature was rejected. At number 6, as per interview, the survey record, Sangeeta Haloi Borwa is out of center area. That was part of the writ proceeding. Now, my lord, may come to the impugned judgment. What was submitted? Page 28 for a moment, the impugned judgment.
Let's file this affidavit.
PPC, I think 2, 3.
No, my lord, the affidavit filed by
That's Sujit Bagladi.
Bagladi.
My lord, may come to the judgment for a moment.
If Mr. Monta, we are absolutely loath in interfering or entering into this appointment of Anganwadis. And that also on such a slender ground. Now the only ground is whether she is out of that area or not.
My lord, the judgment to clarify, lordship, may kindly have a look once. The impugned judgment, my lord. Just one paragraph, kindly, my lord. My lord, may kindly come to page 28, my lord, of the judgment, the impugned judgment. That will clarify everything, my lord.
Mr. Now we do one thing.
Page 28, kindly for a moment.
Just a minute. You can't force your way.
I'm so sorry.
Monta.
I'm so sorry, man. Just pointing out.
If it's just like this, straight away.
Just one paragraph I want.
One paragraph we will see. Why one paragraph? We will have it confirmed. Who appears for the response numbers 2, 3, 5, and 6?
Sharma.
Sharma, come here. Now, when we ask you for an affidavit, you comply only with that aspect, something else which is required. Now, we asked you what is this number, you say it is 23 and not 270. Now, the issue again, now you'll have to file an affidavit again, whether Mr. M.K. Chaudhary falls outside that area or not. File that affidavit. And then we shall not look into anything. That also unnecessarily we entertain. Once it was decided, Mr. Chaudhary has been working for so many years, let it remain. Now, where is this question? But Mr. Mahanta, you made your efforts. Be happy with that. We have asked, now it is clarified. But they choose to reply only what we asked. Something more could have been written that this is 23. They must justify the appointment of Mr. Chaudhary.
The impugned judgment,
We are not going because impugned judgment is under challenge. Why are you taking help of one part? Let us have clarification.
Impugned judgment, they have made an admission. They have made an admission that they belong to 217 in the judgment.
Assuming that they have made an admission.
The respondents.
The respondents have made an admission. But now, for the reason of
that's of course a better way, my lord.
That is better. Ms. S. Sharma. By the advocate representing response number 2, 3, 5, and 6. Shall file an affidavit clearly indicating as to the place of residence of the appellant and respondent number 6, and whether they fall within, whether they fall within the area covered by the Anganwadi Center number 23. वो detail लिख लेना Anganwadi Pub 23 by the next date. Re-notify on July end.
Deeply agree.
31st July.
The records may be publicly honorable sent to the examining the records of office election.
Let the affidavit come, we will see. We are not disturbing the appointment.